We're now joined by retired federal judge Nancy Gertner to discuss the decision and its implications. She's a senior lecturer at Harvard Law School and a BPR contributor. Judge Gertner, thanks so much for your time.
Good to be here.
Yeah, thank you very much, Judge Gertner, for joining us again. So you wrote a piece about this in the Globe, the headline of which was Judge Cannon Follows Clarence Thomas Lead. What did you say about Judge Cannon dismissing this case?
The day that, when the immunity decision came down from the Supreme Court, Justice Thomas writes a concurrence that nobody else joins, he alone, on the illegitimacy, the fact that the special counsel was not authorized to bring the law, to bring anything, to bring any of these lawsuits, that there were issues with the special counsel, that constitutional issues, statutory issues, all sorts of things. What was significant about his concurrence was that the issue was not raised by the parties in the immunity case. You know, not mentioned, not raised, not briefed, not argued. This was essentially Thomas. I read it and I thought immediately that it was Thomas saying to Judge Cannon, hey, go in this direction. Because and judges are not supposed to do that. I couldn't, for example, as the judge said, you know, as a judge say, hey, this case is about XYZ issues, but I want to talk about A and B. So this was already a strange concurrence that no one else joined. What was it? Only 2 weeks later, Judge Cannon issues a lengthy decision adopting his arguments. This is a judge who has been unable to come to a decision with respect to anything, virtually anything. That's an overstatement. Over the past, few years that she's had the case, but this she could do. And it seemed clear to me that she was following Justice Thomas's lead. This comes out the day before the convention begins, and I wondered if she was auditioning for a role in the next Trump administration. I've just heard that Matt Gaetz has posted her picture for the Supreme Court. But I can't, the people will say, and we've talked about this before on this program, what's up with this judge? Is she just inexperienced? Well, an inexperienced judge would go along with the precedent. And the precedent in this case is overwhelmingly in favor of the special counsel. That's what an inexperienced, well, she didn't do that. She held an elaborate hearing, issued this decision. Maybe she's not competent. She actually has a fairly substantial academic background before she became a judge. With this decision, we now know that the issue is she is biased in favor of Trump. She was going to pick an issue out of the air. Again, no other judge had made this kind of decision with the sole exception of Clarence Thomas. So in the op-ed I wrote for the Globe, I said, on the issue of inexperience, incompetence, or bias, we now know the answer.
You know, Judge Gertner, I don't know, can't remember what your opinion was, but the opinion of most legal scholars was of the 4 criminal cases brought against Trump, the one that was the most straightforward and easiest to prove, not easy, but easiest, was this case. Did you agree with that?
Oh, without a doubt. There's no constitutional presidential immunity here because the unlawful retention took place after he left the office. Now, they were going to try to suggest that he had somehow waved his magic wand and had declassified documents right before he left. But that was not going to be easy to prove. So yes, there was no immunity issue here. And it was that, we've talked about this before, it would have been one thing if his defense was the functional equivalent of whoops. I accidentally put nuclear secrets next to my underwear in the box. But you couldn't say whoops with respect to this, this whole string of actions. Boxes, classified documents turned over to the government. The government realizes that it's incomplete. Then there's negotiation. Then Trump's lawyer says that there's no more classified documents. Then people are seen moving boxes. It was not inadvertent and it was not a whoops. And so, yes, this was the most straightforward case. Easiest to prove is always, that's a hard thing to say, but certainly the most straightforward.
Judge Gertner, I wonder if this is unusual. You know that generally speaking, Republican presidents appoint conservative justices or more conservative justices, Democrats, more liberal justices. Sometimes they flip. I remember it was David Souter, the guy that was up for New Hampshire. He turned out to be not quite as conservative maybe as Bush wanted him to be. But is this is this unusual, the way that Cannon is behaving on the lower court, obviously not the Supreme Court, but still?
Well, it's certainly unusual before two things. One is this court, and two is the way Trump selected judges. So this court has made it clear that they're open to re-examining and overturning precedent. So what that does is it creates, there's no ceiling then to lower court judges. If someone raises a off-the-wall argument that they think is interesting, that has never been raised before or has been rejected before, this is a court that seems open to everything. And so, and then we see judges appointed by Trump indulging in that, following that cue. It had not been the case before. And, that I think it's an illusion to suggest that all presidents did that. Bush and, appointed judges that were middle of the road, generally in direct proportion to their never having, annoyed anybody or said anything controversial. Clinton, Obama, and Biden also appointed judges in that mix. So it's, it was moderate right, maybe moderate left. Trump, because of the selection process, has put on the bench people with a clear ideological agenda from beginning to end. And you can only say Judge Kaczmarek in Texas,
right,
who believes
The Mifepristone judge.
Yes.
Yeah.
That's right, the Mifepristone judge, who believes that even as a district court judge is not allowed to doesn't overturn Supreme Court precedent. You're bound by the precedent. You could say, I think I've told you before, I would file an OI footnote in which I would say, I really don't think this is right. This is ridiculous, but I would have to follow it. All of a sudden, you have a generation of judges where there's no ceiling, where they can, deal with constitutional arguments that no one had ever, that the Supreme Court has rejected, and be valued for it. And she's in that category.
By the way, I would love to see that footnote where you wrote, "Oi, this is ridiculous." By the way, Judge Gertner, if you don't know, was nominated by Bill Clinton. One last thing on this case. The appellate court that's reversed her, I think twice already on Trump-related things in pretty heavy-handed fashion. I'm assuming Jack Smith, the government will appeal the decision. It goes there. You intimated in your piece in the Globe that in addition to reversal, which would obviously, if it happens, happen long after the election, assuming the case is still live, which would probably not be if Donald Trump is elected, that they might dump her from the case. Could you flesh that out a little bit?
The Court of Appeals always has the option of reassigning a case. Usually that's done when a judge has been made fact findings with which the court, actually that's not making fact findings, but it's very rare. It's not a usual kind of thing, but a Court of Appeals could reassign a judge that seems too embroiled in the case, for example. As I said, it's unusual. That would be a reversal and reassignment. The 11th Circuit has an interesting process, which is that there was a case that I linked to in my piece where a judge was reversed twice, very strong reversal. And then the case that went up was the third time, and the court said, enough is enough, we will reassign. And it wasn't the usual kind of reassignment. In other words, when a judge makes a decision of law, you don't think that a judge is embroiled in the case in any way. So it's unusual to reassign. But they said quite clearly, this judge has, essentially been reversed twice before. Enough is enough. And I think that given the strength of Cannon's reversals, where the court said essentially, what the hell are you talking about? Intervening in the investigative process as you have. She, if you recall, was intervening in the grand jury process, which is just totally inappropriate. So they reversed her thunderously, and Jack Smith doesn't even have to move to disqualify her. They could simply reassign her if they reverse this this decision, as I think they would, but because I don't think that the 11th Circuit, believes that all constitutional issues are up for grabs.
Judge Gertner, why, Jim mentioned this, it would take a very long time, though. Why would it take so long for the 11th Circuit to act? And what
It doesn't have. It
I
doesn't
just meant
have,
I meant post-election. I'm
Okay.
sorry.
Yeah,
I misspoke. Yeah.
I mean, it doesn't have to take long. They could, the other thing that the Supreme Court is behaving so in such a troubling fashion in so many ways. The Supreme Court could grab the case. In other words, they can appeal, and the Supreme Court could grab the case. Whether they do so depends on whether or not there's any parallel support for what Justice Thomas said.
Wait a minute. They could grab the case from the 11th Circuit before the 11th Circuit had a chance to reverse
Yes.
and reassign? So
Yes.
they could be knocked out completely.
Yes.
Wow.
And that has been done. There would be no justification for it because there's no emergency here. But they could, essentially what Trump could do is move for an expedited direct appeal to the Supreme Court. And there have been instances in which that has happened, where they don't wait for the Court of Appeals to make a decision.
And they could issue the decision to celebrate Justice Kavanaugh's 90th birthday. They could hold it for that. So, Judge Gertner, if we could do a review of everything. So this, as of the moment, the classified documents case, the most straightforward, has been dismissed. The state prosecution in Georgia is on hold because of a challenge to the status of the DA, Fani Willis. The insurrection case in Washington is on hold because of the immunity decision from the Supreme Court. And most shockingly, well, it's no more shocking than this Cannon thing, Judge Merchan, in the case in which Trump was convicted of 36 felonies for trying to interfere in an election around this hush money stuff, so it put off sentencing from July, I think, 11th till September, and he used the term if there is a sentencing. And what that is interpreted to mean is because the Supreme Court, correct me if I'm wrong anywhere along here, in its immunity decision said that not only can you not prosecute a president for any of his, quote, core functions, but you can't use anything about his core functions in evidence to prove that he violated the criminal law in things where he can be prosecuted. Amy Coney Barrett didn't agree with that, but the majority did. And apparently the testimony of Hope Hicks in this trial and her discussion with Trump, and one other thing which I can't remember.
The tweets,
while part of his core function, may cause Judge Merchan himself to determine that that testimony was so material to the conviction that that conviction or those convictions gets thrown out too. Is that an accurate retelling?
Yes, although start with the Bragg case and with Judge Merchan.
Yeah.
He's making a decision whether or not that the court distinguished between two kinds of official acts. The Supreme Court.
Yeah.
One's core constitutional functions, the pardon power, and dealing with the DOJ was a core constitutional function. The second category that wasn't core was an official act, which was presumed to be immune, but the presumption could be overcome. We're dealing with discussions that Hicks had with Trump in the Oval Office about paying off a porn star.
Right.
Now, unless the Constitution is dramatically changed, that's really not a core constitutional function. That would have to, really, maybe it has to.
But he did it while he was president, while talking to a presidential aide, they would argue. And even though the payoff in an attempt to affect the outcome of the election obviously is not a core function nor a semi-core function because he wasn't president when he did it, his lawyers will make the argument that Hope Hicks conversation was inappropriate to be used as testimony, right?
Again, but it would be, they're going to argue that it was official because of where it took place and Hicks's status. That presumption can be overcome when you say, hey, this is not about, national security. This conversation was about sex. And again, that's sort of not a core function, or maybe with President Trump it would be. I don't know, but that it can be. Oh,
Oh,
you know,
God.
that's not a core function. So that is, and then if he finds that it is an official act, this second category, then he has to decide if it's harmless error. He has to
Right,
decide whether it's so affected
right.
the outcome, or he could find that Trump waived the argument, never challenged this argument, never made this argument in court. So it's not clear that that doesn't go forward. I suspect he put this off because of, because of vacations, and because he wanted to digest a lengthy and complicated immunity decision. So I don't think that that necessarily means that that's off the table. What kind of pressure um, the judge will feel in terms of the sentence is another question. Um, the January 6th case could result in a mini trial on what's in and what's out. In other words, there's core constitutional function that's really not implicated in the January 6th prosecution. Second, there are official acts which are presumed to be immune, but you can rebut that presumption. And so the question is what in the January 6th case is official and what's not requires a hearing. And so Judge Chutkin in the DC District Court, where this case is, can hold a hearing on what's in and what's out. That hearing would be interesting.
When the hell's that hearing happening?
Well, she hasn't said it yet, but that could be a hearing that could take place, anytime over the summer. It's not a finding of guilt. It would be a finding of the result of that would not be a finding of guilt. It would be what acts are still
Yeah.
in the pot here and what acts are not.
Well, some of those charges are knocked out anyway because of the other Supreme Court decision around the obstruction of whatever the hell it was, justice.
Actually, that's not
charge.
that's not clear. That's not clear, Jim, because the Fisher case is the case you're talking about. The Fisher case was a case in which they narrowed the obstruction of justice statute, the interpretation, so it's more closely aligned to impairing or impeding or obliterating documents, and not necessarily a physical proceeding, not necessarily. The January 6th case includes the false elector scheme, and the false elector scheme is about false documents.
Okay.
Yeah,
So
they're,
it's not
they're
it's not
back.
clear that was wiping it out.
Can I ask you one last technical question? So you were a judge and a great defense lawyer for decades and decades. Here's the technical question. Is Donald Trump the luckiest defendant in the history of the United States of America? I'm serious.
Yes. No, it's extraordinary. I mean, I think, I think we'll be sorting this through for years. But one thing that has happened is that judges are bending over backwards in ways they don't do for the ordinary defendant to give him time and to give him an opportunity, to give him more due process than anybody ever gets.
At the same time that they're going out of their way to saying no person is above the law.
Except I see it differently
Right.
than the luckiest person. I see it as someone who's able to fundraise millions and millions and millions and millions of dollars so that he can afford to pay $50 million in 1 year to these lawyers who are going to object to every single thing that
They didn't
moves
even
in the
raise
courtroom.
some of these issues that
I
he's
know,
gotten away with.
But I think that, to me, that is the issue, the unfairness of the justice system in general to the extremely wealthy and the regular Joe or Jane.
No, that's true. That's really true. So I was a defense lawyer, and it was clear that delay was an important part of what you wanted to do, because if you kick the can down the road, maybe the prosecutor would lose interest in the case.
Yeah.
Maybe likewise you would raise every legal and constitutional argument you could. I think that's true. I believe in zealous advocacy for both sides, but especially the person facing prison. The problem here is that it's not a problem. I mean, judges have indulged many of the arguments that he has made, have given him hearing time that no one else had. And then you add to, which is, again, I don't disagree with, but you add to this a Supreme Court that candidly has bent over backwards
For
in
Donald
ways
Trump.
that stunned
Yeah.
it.
You know,
So the combination of challenge everything, which is fine, hold elaborate hearings, which is fine, but suddenly you have a court that is prepared to act in ways that no one ever anticipated.
I just one more question about this. I understand Jim and I were talking about this before the show that there you can be convicted of a crime and then years later this happened with juveniles who got life sentences for murders they committed. The Supreme Court said they weren't going to do that anymore. But it just seems odd. I'm not a lawyer. In the Merchant election interference case where you had the jury and they decided that Trump was guilty of all these felonies and we were awaiting sentencing. Then after the court case, the Supreme Court issues this immunity thing, which calls into question that part of the testimony about Hope Hicks, talking about sex with a porn star and the payments for that. But I think I can't be the only layperson to whom it seems odd that the crimes are committed, and then after they're committed, you get a ruling which undermines what the jury decided. You know what I mean? Retroactivity is what I'm talking about.
Well, I mean, I think that the issue with the Bragg election interference case is that presidential immunity is an unusual claim, right? The ordinary defendant doesn't have that kind of claim, and the metes and bounds of immunity were never plumbed before, were never examined before. So I think that that's the reason this happened. But I can't say it enough, and I've said it on this program. Judge Chutkan issues a very elaborate ruling on immunity that says, I don't know what immunity is in every conceivable case, but I know that interfering with the peaceful transfer of power is not immune.
Right.
And so these allegations, this complaint, this concrete story is not immune. The District of Columbia Circuit did the same thing. I don't know what immunity is in general. I'm not a legislature. I don't legislate for all imaginable contingency. I decide the case in front of me. The case in front of me is Donald Trump behaving not as president, meddling in state electoral systems in which he had no authority to do. This doesn't count. I don't know what immunity is in other situations, but this doesn't count. The Supreme Court decides to take on the issue. And if you recall, Gorsuch said, we're writing a decision for the ages. And I wish I was in the courtroom. I would have raised my hand and said, no, you're not. You're deciding this case. That's all, not for the ages. You're not a legislature. You're deciding were these allegations at this time immune. And they could have simply said not and leave for the next case, if it ever came, the discussion of immunity. That's what a court would do. That's called judicial restraint. That's what you focus only on the case in front of you, not the case that you think is coming down the line. So that's the problem here is this Supreme Court, that decision, I don't think, I certainly didn't expect anything like that. After the oral argument, you might have, but nobody expected anything that elaborate, and its elaborateness alone will delay everything.
Can you call us back when you have some good news about anything? Is that possible? Thank you. Judge Gertner, fabulous to talk to you as always. Really appreciate your time.